Hello guys, this is Prachi working as an intern at LEXIQ and Company, and the topic I'm going to discuss today with you all is dying declaration under the evidence law. So basically in this video I'm going to cover what is dying declaration, various types of dying declaration, how a dying declaration can be recorded, and the grounds for admitting dying declaration. So when an offense has been committed, basically two persons are involved in it. One person is the accused who has committed the crime, other one is the victim with whose the offense has been committed. So in order to prove their positions and make one story to be true, they both give their respective statements to the judge. But their stories cannot be relied upon as it may be prejudiced or may be untrue. So in this, the role of the witness becomes very crucial. But there is a condition to it. When the statement made by a person to be treated as a true evidence in spite of the fact that it has been made in his own favor and hardly any doubt behind the reason for that statement, that condition is called dying declaration. So let's just know what is dying declaration in the legal terms. So a dying declaration according to section 32 of the Evidence Act is when the statement is made by a person as to the cause of his death or the circumstances of the transaction which resulted into his death in cases in which the cause of his death is in question. Such statements are relevant whether the person who made them was or was not at the time when they were made under the expectation of death, and whatever may be the nature of the proceedings in which the cause of his death is in question. So this is the basic definition of dying declaration, and let's just know what are the various forms of it. So there is no particular form in which a dying declaration must be made. It can be oral, it can be written, it may be in the form of question and answer, and it can also be recorded in the form of gestures and signs. However, there must be a distinct and definite assertion on the part of the person who produced the statement. So let's just take a recent example of this, that in Nirbhaya case, dying declaration was made by her in the form of signs and gestures. The dying declaration made by Nirbhaya was recorded. So dying declaration made through signs and gesture are admissible under the evidence law. So now if the person making the dying declaration has chances to live, his statement is inadmissible as a dying declaration, but it might be relied on under section 157 to corroborate his testimony when examined. Such a statement can also be used to contradict him under section 145. So now let's just discuss how a dying declaration can be recorded. A statement of the deceased would, in its literal and natural sense means a statement in the word of the deceased. And whenever it is practicable to record the statement in those words, it must be recorded in the words of the deceased only. When the statement is the result of the replies to the question, it is not possible to assess fully the value of the replies without knowing what the questions were, since the replies are always given with reference to the question put in. It is therefore becomes essential to record the questions in the precise words in which the questions are put to the deceased, and take down the answers in the actual words in which those answers were given. So these are the held in the cases Sharinath Durga Prasad versus the state. Now let's take some another example, that is in Kusa versus state of Orissa. Supreme Court held that if a deceased fails to complete the main sentence, a dying declaration would be unreliable. However, if the deceased has narrated the full story but fails to answer the last question as to what more he wanted to say, then that declaration can be relied upon and is admissible under the evidence law. The Supreme Court also laid down that if a dying declaration is believed by a court, a conviction can be based upon it without any further corroboration. Let's take some another example, that in the state of UP versus Suresh, the deceased who made the dying declaration was seriously injured but was conscious throughout making his statement. The Supreme Court in this case held that minor incoherence in his statement with regard to facts and circumstances would not be sufficient ground for not relying on his statement which was otherwise found to be genuine. Now let's talk about the grounds for admitting dying declaration. First ground is death of the defendant. Death of the defendant is necessary for the admission of the dying declaration. Second is necessity. The victim being generally the only eyewitness to the crime, the exclusion of his statement would tend to defeat the ends of the justice. Our third ground is the sense of impending death, which creates a sanction equal to the obligation of an oath. The general principles on which dying declarations are admitted is that they are declarations made in extreme conditions when the party is at the point of the death and when every hope of the world is gone, when every motive to speak falsehood is silenced and the mind is induced by the most powerful consideration to speak the truth. A situation so solemn, so lawful is considered by the law as creating an obligation equal to that which is imposed by a positive oath administered in the court of justice. So these are the grounds for admitting the dying declaration. Now let's just move further and talk about the method of proving dying declaration. Statements, whether oral or written, must be duly proved. If the statement is oral, persons who heard the statement should depose what they have heard. In the case of written statements, it must be proved by the evidence of the person who recorded that statement. If a dying declaration is made to a magistrate, whether such a statement itself can be admitted as evidence without calling the magistrate as a witness has been subjected to a great deal of controversy. But the more accepted view is that under Section 80 is not applicable to a dying declaration made to a magistrate. Therefore, the magistrate must be duly called to prove the dying declaration which is made by the deceased. Now let's just take another example, which is in Ratan Gond versus State of UP. It was held that a dying declaration cannot be proved unless the death of the person who made the declaration is also proved. Now the question for consideration is, can a conviction be based solely on the dying declaration? We can answer this question through a case analysis, which is in Ramnath versus State 1953. The Supreme Court has observed that it is a settled law that it is not safe to convict an accused person merely on the evidence furnished by a dying declaration without further corroboration, because such a statement is not made on oath and is not subjected to cross-examination, and because the maker of such a statement might be mentally and physically in a state of confusion and might well be drawing upon his imagination when he was making the declaration. But, however, the observation of their lordships in the above case was held to be in the nature of obiter dicta in Khushal Rao versus State of Bombay, and in this case, the following principles were laid down by their lordships. That is, first principle is, it cannot be laid down as an absolute rule of law that a dying declaration cannot be formed the sole basis of the conviction unless it is further corroborated. Our second principle is, each case must be determined on its own fact, keeping in view the circumstances in which the dying declaration was made. Our fourth fact is, a dying declaration stands on the same footing as any other piece of evidence and has to be judged in the light of surrounding circumstances and with reference to the principles governing the weighing of evidence. In order to test the reliability of dying declaration, the court has to keep in view several circumstances, that is, like the opportunity of the dying man for observation and etc. Hence, in order to pass the reliability test, a dying declaration has to be subjected to a very close scrutiny, keeping in view the fact that the statement has been made in the absence of the accused, who had no opportunity of testing the veracity of the statement by cross-examination. So these are the topics that are covered for today in the dying declaration. I hope you guys found this video really helpful for you. So that's all for today's video. Thank you so much.